The billing alert appeared at 11:47 p.m. on a Tuesday, flagging a disbursement I never authorized. I'm Thornton Yardley, 42 years old, E-Discovery Counsel at one of Louisville's premier partnerships. For the past 8 years, I've specialized in complex litigation support and digital evidence management. The firm handles everything from corporate mergers to white-collar defense, and my role keeps me buried in case management systems and electronic discovery protocols. The alert came through our automated billing system, a routine notification about expense approvals exceeding $5,000. Except I was reviewing contingency fee matters, cases where we only collect if we win. Disbursements on contingency work require partner approval and detailed documentation. This one showed a $12,500 payment to Meridian Consulting Services, charged against the Blackstone Industries securities fraud case, my case. The timestamp read 9:23 p.m., 3 hours earlier. I'd left the office at 6. I pulled up the case file in our management system. The Blackstone matter was our biggest active contingency case, a class action representing investors who lost millions when the company's executives allegedly manipulated earnings reports. We'd been working it for 18 months. If we won, the firm stood to collect 30% of a settlement that could reach 8 figures. The disbursement entry looked legitimate at first glance. Professional formatting, proper case coding, even a vendor invoice number. But I'd never heard of Meridian Consulting Services. More troubling, the approval signature showed my electronic authorization, the same digital signature I used for all case-related expenses. I checked my email. No requests for approval, no vendor contracts, no documentation trail. The system logs showed the entry was created from my workstation, using my login credentials. According to the timestamp, I'd been sitting in my office at 9:23 p.m., authorizing a payment to a consulting firm I'd never contracted. I scrolled through recent disbursements on the Blackstone case. Expert witness fees, court reporter costs, document production expenses, all legitimate, all properly documented. This Meridian payment stood out like a forgery in a stack of authentic signatures. My phone buzzed. A text from Dallas Juniper, our office manager. "Working late again? Saw your office light on when I left." I glanced at my watch, nearly midnight. Dallas had sent the message at 9:45 p.m., 22 minutes after someone using my credentials had authorized the mysterious payment. The pieces didn't align. If Dallas saw my office light on at 9:45, who had accessed my workstation earlier? And why would someone create a fake consulting expense on our most valuable case? I pulled up the vendor database and searched for Meridian Consulting Services. No results. I checked our accounts payable system. The payment was scheduled to process in the morning, direct deposit to a bank account I didn't recognize. The Blackstone case represented more than just money for the firm. It was our reputation case, the kind of high-profile litigation that established credibility in the securities fraud market. Any irregularities could trigger bar complaints, client lawsuits, or worse. I saved screenshots of the disbursement entry and system logs to my personal drive. Whatever was happening, I needed documentation before anyone realized I'd discovered it. The office felt different at midnight, shadows longer, sounds amplified. I'd worked late countless times, but tonight the familiar space seemed foreign. Someone had been here, using my access, manipulating our most important case. I locked my computer and gathered my files. Tomorrow I'd dig deeper into the Meridian payment and trace the digital footprints. But as I walked toward the elevator, one question echoed in my mind. If someone could forge my authorization this easily, what else had they already done? The next morning arrived with the weight of unfinished questions. I reached the office at 6:30 a.m., 2 hours before normal operations began. The building's silence felt protective. No interruptions, no casual conversations to deflect my investigation. I started with the Meridian Consulting payment. The transaction had processed overnight, $47,500 transferred to an account registered under Delaware corporate records. The routing number traced to a regional bank in Lexington, but the account holder information remained sealed behind privacy protocols. Dallas Juniper had managed our office operations for 8 years. We'd worked together on the firm's biggest securities fraud case, the Morrison Industries litigation that established our reputation in complex financial disputes. She'd coordinated expert witnesses, managed discovery timelines, and handled sensitive client communications with absolute precision. Trust builds slowly in legal partnerships. Dallas had earned mine through countless late nights, emergency filings, and crisis management situations. When clients panicked about depositions, she calmed them. When opposing counsel played procedural games, she anticipated their moves. Her competence had become invisible, the kind of reliability that makes law firms function. I pulled up our case management system and searched for all Meridian Consulting entries. 3 additional payments appeared, each on different contingency cases, each authorized during evening hours when I wasn't in the office. The amounts varied: $23,800, $31,200, and $52,900. Total unauthorized disbursements: $155,400. The pattern emerged clearly. Every payment occurred on cases where I served as lead counsel. Every authorization used my digital signature. Every transaction happened after business hours, typically between 8 o'clock and 10 p.m. I checked the access logs for my workstation. The timestamps showed consistent evening logins, always from my computer, always during periods when I was documented elsewhere. Court appearances, client dinners, bar association meetings. Someone with administrative privileges had been systematically accessing my account. My phone rang. Dallas Juniper's name appeared on the caller ID. "Morning, Thornton. You're in early today." "Catching up on some case reviews," I said, keeping my voice neutral. "The Blackstone team meeting is at 10. Do you need me to prepare anything specific?" "Just the standard discovery update. Nothing unusual." "Perfect. I'll have everything ready." The call ended, but her timing felt deliberate. Had she noticed my early arrival? Was she monitoring my activities the same way I was now monitoring hers? I opened the firm's personnel database and reviewed Dallas's access permissions. As office manager, she held administrative rights to our case management system, billing software, and client databases. She could generate reports, modify entries, and authorize payments up to $75,000 without partner approval, a privilege designed to streamline operations. The Meridian payments fell within her authorization limits. Technically, she didn't need my digital signature to process them. But using my credentials created a false paper trail, making me appear responsible for decisions I'd never made. I called our IT consultant, Veronica Juniper, who handled our cybersecurity protocols. "Thornton, what can I help you with?" "I need to review some access logs, specifically evening logins to my workstation over the past 6 months. Is there a security concern?" "Potentially. Can you generate a detailed report?" "Absolutely. I'll have it to you within an hour." Veronica's report arrived at 9:15 a.m. The data confirmed my suspicions. 43 unauthorized access events, all during documented periods when I was away from the office. Each session lasted between 12 and 18 minutes, enough time to review case files, authorize payments, and clear browser histories. The access pattern showed sophisticated planning. Whoever was using my credentials had studied my schedule, identified optimal windows, and executed a systematic fraud operation. This wasn't opportunistic theft, it was calculated embezzlement. I printed the access logs and locked them in my desk drawer. The Blackstone team meeting would begin in 30 minutes, and I needed to observe Dallas's behavior without revealing my investigation. The conference room filled with associates, paralegals, and support staff. Dallas entered precisely at 10 o'clock, carrying her usual stack of organized files and status reports. She distributed discovery timelines, updated case budgets, and reviewed upcoming deadlines with characteristic efficiency. "Any questions about the expert witness schedule?" she asked. I watched her face, searching for signs of stress or deception. Her expression remained professional, focused, completely normal. If she was stealing from the firm, she'd mastered the art of compartmentalization. "The consulting expenses look higher than projected," I said, testing her reaction. "Which consultants specifically?" Dallas asked, pulling up her budget spreadsheet. "Meridian Consulting Services. I don't recall approving their engagement." She paused for exactly 2 seconds, long enough to register the question, not long enough to suggest panic. "I'll double-check the authorization paperwork after the meeting," she said. "Sometimes the vendor names get abbreviated in our system." The meeting continued for another 20 minutes. Dallas answered questions, provided updates, and maintained her usual professional demeanor. But I'd seen the pause, the momentary calculation before her response. She knew exactly what Meridian Consulting Services was. After the meeting, I returned to my office and called our bank's fraud prevention department. I explained the situation in general terms: unauthorized payments, potential identity theft, need for account monitoring. They agreed to flag any future transactions involving Meridian Consulting and provide detailed records for the existing payments. The bank's investigation revealed disturbing details. The Meridian account had been opened 6 months ago using forged corporate documents. The beneficial owner information listed a shell company registered in Nevada, but the actual account access belonged to someone with intimate knowledge of our firm's operations. I had enough evidence to confront Dallas directly, but I needed to understand the full scope of her operation. How many other cases were affected? Were other attorneys' credentials compromised? Had client funds been diverted? I spent the afternoon reviewing every case file where Dallas had administrative access. The pattern extended beyond my cases. Unauthorized consulting payments appeared on matters handled by 3 other partners, always during evening hours, always using forged authorizations. Total theft: $847,300 over 18 months. Dallas Juniper had systematically embezzled nearly $1 million from our firm, using her administrative privileges and our trust to fund what appeared to be a sophisticated money laundering operation. She'd studied our schedules, exploited our security protocols, and created false documentation to cover her tracks. The woman I'd trusted with our most sensitive cases, the professional who'd helped build our reputation in complex litigation, had been stealing from us since the day she gained administrative access to our financial systems. Monday morning, I arrived at the office before dawn. The evidence against Dallas was overwhelming, but I needed to secure our systems before confronting her. I called our IT contractor and requested immediate password resets for all administrative accounts. Then I contacted Kevin Brown at the Federal Economic Crime Review Bureau. "Mr. Yardley, based on your preliminary report, we're opening a formal investigation," Brown said during our 8 a.m. call. "Don't confront the suspect yet. We need to monitor her activities and secure additional evidence." I agreed to wait, but Dallas made that impossible. At 9:15, she knocked on my office door. "Thornton, I need to discuss the Meridian payments. There's been a misunderstanding." I gestured to the chair across from my desk. "Please, sit down." Dallas closed the door and took her seat. Her usual confidence had vanished, replaced by careful calculation. "I know you've been reviewing the financial records. I can explain everything." "I'm listening." Meridian Consulting provides specialized case management services. The payments were authorized under our general administrative budget. I have documentation. I opened my laptop and displayed the forged authorization forms. "These documents? The ones with fabricated partner signatures?" Her composure cracked slightly. "Those signatures were obtained verbally. I documented the approvals according to standard procedure." "Dallas, I've verified every signature. None of the partners authorized these payments. The Meridian account was opened using falsified corporate documents. You've stolen $847,300 from this firm." She sat silent for 30 seconds, then straightened in her chair. "You can't prove intent to defraud. Administrative errors happen in complex financial environments. I was following established protocols." "The protocols you established?" "The same protocols that gave you access to partner credentials and client account information." Dallas stood abruptly. "I think we should involve the managing partners before making accusations." "They're already involved. So is the Federal Economic Crime Review Bureau." Her face went pale. You contacted federal investigators without discussing this internally? The theft crossed state lines. Meridian's Nevada registration makes this a federal matter. She moved toward the door, then stopped. Thornton, we've worked together for 3 years. I've helped you win major cases, protected client confidentiality, maintained this firm's reputation. One administrative dispute shouldn't destroy that relationship. This isn't a dispute, it's systematic embezzlement. Dallas left without another word. Within an hour, Kevin Brown arrived with 2 federal agents. They interviewed me for 90 minutes, reviewing the evidence I'd compiled. Brown confirmed that Meridian Consulting was connected to a larger money laundering investigation involving multiple law firms across the Southeast. Ms. Juniper targeted firms with significant contingency practices, Brown explained. She'd gain administrative access, study the financial systems, then create shell companies to receive unauthorized payments. Your firm was her most successful operation. The managing partners called an emergency meeting for 2 p.m. I presented my findings to the full partnership, the forged documents, the shell company structure, the systematic theft pattern. The room remained silent as I detailed Dallas's methodology. Senior partner Veronica Juniper spoke first. How long has this been happening? 18 months. She began small, $5,000 here, $10,000 there. The amounts increased as she gained confidence in the system. What's our exposure? Financial loss is $847,300. Potential malpractice claims if clients discover their matters were compromised. Bar discipline if we failed to properly supervise trust accounts. The partnership voted unanimously to terminate Dallas immediately and pursue criminal charges. We also agreed to notify all affected clients and implement enhanced financial controls. Dallas was arrested Tuesday morning at her apartment. Federal agents found detailed records of her operation, including plans to target additional firms in Nashville and Atlanta. The evidence included forged corporate documents, fake identification cards, and financial records showing the stolen funds had been transferred to offshore accounts. Kevin Brown called me Wednesday afternoon. Ms. Juniper has agreed to cooperate with our investigation. She's providing information about similar schemes at other firms. In exchange, she'll plead guilty to federal wire fraud charges. What's the likely sentence? 5 to 7 years plus full restitution. The cooperation agreement might reduce that slightly. I spent the following weeks rebuilding our financial systems and meeting with affected clients. Most understood the situation and appreciated our transparency. 2 clients filed malpractice suits, but our insurance covered the settlements. The Kentucky Bar Association opened its own investigation. I testified at a disciplinary hearing, explaining our supervision procedures and the steps we'd taken to prevent future incidents. The bar found no ethical violations by the firm, but recommended enhanced oversight protocols for all administrative staff. Dallas pled guilty in federal court 6 weeks later. The judge sentenced her to 63 months in prison and ordered full restitution. During her allocution, she admitted to targeting our firm specifically because of our success in contingency litigation. I studied their case management systems for months before applying for the position, she told the court. I knew exactly how to exploit their trust and their procedures. The Federal Economic Crime Review Bureau's investigation expanded to include 12 other law firms. Dallas's cooperation led to the discovery of a network of administrative staff who'd been recruited to commit similar thefts. The total loss across all firms exceeded $4 million. I helped 3 other attorneys whose firms had been targeted. We shared information about security protocols and worked together to identify additional victims. The experience taught me that trust in professional relationships requires constant verification. Our firm recovered most of the stolen funds through asset forfeiture proceedings. The insurance settlements covered our remaining losses. More importantly, we'd prevented Dallas from targeting other firms and helped federal investigators dismantle a sophisticated criminal network. The betrayal had shaken our partnership's foundation, but it also strengthened our commitment to transparency and accountability. We implemented new oversight procedures, enhanced our financial controls, and created protocols for regular security audits. 6 months after Dallas's sentencing, I received a letter from Kevin Brown. The Federal Economic Crime Review Bureau had used our case as a model for training other law enforcement agencies. Our cooperation had been instrumental in preventing similar crimes at dozens of other firms. Justice had been served, but the cost extended beyond financial losses. 12 months later, I stood in my new office overlooking the Ohio River. The morning light filtered through floor-to-ceiling windows, illuminating the simple nameplate on my desk. Thornton Yardley, attorney at law. I built a boutique practice handling financial abuse and legal partnerships. The work felt purposeful in ways my previous corporate litigation never had. 3 former partners from other firms had joined me, each bringing their own stories of betrayal and recovery. My first major case involved a paralegal who'd embezzled $200,000 from a personal injury firm in Lexington. The patterns were familiar: unauthorized disbursements, altered timestamps, exploited trust relationships. We recovered 90% of the stolen funds and helped the firm implement security protocols that prevented future theft. The Federal Economic Crime Review Bureau referred cases to us regularly. Kevin Brown had become an unexpected ally, sending firms that needed both legal representation and operational guidance. Our success rate in recovering stolen assets exceeded 80%. Dallas Juniper remained in federal prison. Her cooperation had led to 17 additional convictions across 6 states. The criminal network she'd helped expose had stolen over $8 million from law firms nationwide. Her testimony continued to be valuable in ongoing prosecutions. My former partnership had thrived despite the betrayal. Veronica Juniper had been promoted to senior partner, leading their new financial oversight committee. The enhanced security protocols we'd implemented became industry standards, adopted by firms across Kentucky and beyond. The experience had changed my perspective on professional relationships. Trust remained essential, but verification had become equally important. Every client engagement now included detailed financial controls and regular audit procedures. I'd testified before the Kentucky Bar Association's Ethics Committee about administrative oversight in law firms. My recommendations became part of their continuing education requirements for managing partners. The presentation had been downloaded over 3,000 times from their website. The betrayal had cost our firm nearly $1 million and months of disruption, but it had also revealed the importance of vigilance in professional partnerships. The lessons learned had prevented similar crimes at dozens of other firms. My new practice occupied the top floor of a renovated warehouse in downtown Louisville. The exposed brick walls and hardwood floors created an atmosphere of authenticity that clients appreciated. We'd grown from 4 attorneys to 12 in less than a year. The phone rang less frequently now, but each case carried more weight. Helping other attorneys recover from financial betrayal felt like meaningful work. The complexity of each investigation required the same analytical skills I'd developed in securities litigation, but the human element made every victory more satisfying. Evening approached as I reviewed files for tomorrow's depositions. The city lights reflected off the river below, creating patterns that shifted with the current. The view reminded me that some things remained constant, even when others changed dramatically. The betrayal had ended, but its impact continued to shape my work and my understanding of professional trust. Every case we handled helped other firms avoid similar devastation. The network of attorneys we'd built shared information and resources that strengthened the entire legal community. It was finally over, and the silence felt earned.